Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we are just about a month away from the United States Supreme Court going back into session. And during the spring and summer months, that's when there is a lot of petitions that are filed with the Supreme Court asking for review. And they are already seeing some of these cases get scheduled for conferences coming this fall. What I decided to do was go back to about April 1st, so approximately 5 months ago, and took a look at every single new filing that has been filed before the United States Supreme Court that relates to your Second Amendment rights. Let's get through it today. We'll kind of try to do it in rapid fire fashion. So today, let's spend a few minutes and let's talk about a rundown on every new gun case before the Supreme Court. Okay, America, we're going to be talking about cases that are headed to the Supreme Court. Now, when I say headed to the Supreme Court, what I mean is they are asking for an invite. As we know, especially if you geeked out following Snope v. Brown and Ocean State Tactical v. Rhode Island with us live every Monday morning for about 3 months, you will know that nothing is guaranteed when it comes to the United States Supreme Court. I'm going to break these down by some of the more popular categories. I will point out that this is not every single case that has been filed because there's a lot more, and some of them have some obscure issues, but I will give you a rundown of everything that has been filed. Let's start off first with magazine bans. We have 2 new filings before the United States Supreme Court since April 1st. That includes Duncan v. Bonta, filed on August 15th, a case that really needs no introduction whatsoever. It is the granddaddy of all magazine ban cases, and candidly, if ever there was a case where the record has had ample opportunity to percolate at this point, it would be Duncan v. Bonta. There's also the case of Gators Customs Guns v. State of Washington, which was filed on August 6th. That comes out of the Washington State Supreme Court. We've done this video about it as well. And again, that comes after a 3-day trial down in Cowlitz County, Washington, so it has a very well-developed record. Okay, the prohibitions on 18, 19, and 20-year-olds being able to purchase firearms. And I will tell you that I find it hard to see how the United States Supreme Court can actually not accept one of these cases. And there's why. We have a massive circuit split on that. Depending on where you live geographically in the country, you may or may not be able to purchase firearm if you're 19 or 20 years old. Since April 1st, we have had the following filings. West Virginia Citizens Defense League versus ATF, filed July 31st. That comes out of the 4th Circuit Court of Appeals. McCoy versus ATF, filed on July 31st. Paris v. Lara, filed on June 25th. That comes out of the 3rd Circuit, and also NRA v. Glass, filed May 16th. That comes out of the 11th Circuit. Now, that is only the cases that have been filed since April 1st. There are a litany of other cases that are already pending before the United States Supreme Court addressing this exact issue. Let's talk about cannabis users or users of controlled substances in general, because that too has become kind of a hotter issue. Since April 1st, we have had the following cases petitioned to the United States Supreme Court. United States v. Baxter, filed June 27th. That's out of the 8th Circuit. United States v. Sam, filed June 5th. That's out of the 5th Circuit. United States v. Daniels, filed June 5th. That is also out of the 5th Circuit, and that is a case that we have actually done a couple of videos on. There are more. United States v. Cooper, also filed June 5th. That is out of the 8th Circuit, and there is one other case that also has been filed since April 1st that addresses these issues. Essentially, this is the prohibitions found in 18 United States Code Section 922G, which prohibit the users of unlawful controlled substances from possessing a firearm. Now, let's talk about felons, whether they're any type of felon or just nonviolent felon, and their possession of firearms or challenges again to portions of 18 United States Code Section 922, which prohibit that. There is no issue which has had more cases filed since April 1st than this particular issue. Just to give you a sample of what's been filed, Ford versus the United States, filed June 25th out of the 5th Circuit. Sam versus United States, filed June 25th out of the 1st Circuit. Alvarez versus the United States, filed June 24th out of the 5th Circuit. Medrano versus United States, filed June 24th out of the 5th Circuit. Judd versus the United States, filed June 23rd out of the 5th Circuit. Thomas versus the United States, filed June 12th out of the 10th Circuit. And there are 19 more cases, 19 more petitions, which have been filed on this issue since April 1st of this year. Okay, let's talk about assault weapon bans, because it perhaps is the issue we talk about more frequently than any other particular legal issue. There is, shockingly, at this time, only one case that is under petition to the United States Supreme Court dealing with an assault weapon ban. That was Viramontes v. Cook County, which was just filed on August 27th. That comes out of the 7th Circuit. Now, that is a challenge to Cook County's assault weapon ban. This is not the full Protect Illinois Communities Act that's being challenged in Harrell v. Raoul, set for oral arguments before the 7th Circuit on September 22nd. So at the current time, if you're just trying to handicap who's in pole position on an assault weapon ban, it's only one case right now, and that is Viramontes v. Cook County. There is, however, the case of Rush versus the United States, filed June 25th out of the 7th Circuit. That is a challenge to the prohibitions against possessing short barrel rifles unless they are properly registered as an NFA item. So that is a quick rundown on everything that's been filed since April 1st. There's actually a couple other interesting outliers that we discovered. We're going to do separate videos about that. Now, again, you guys have been through this with us before. You know, just because they are petitioning to the United States Supreme Court, that has absolutely no guarantee that any of these cases will get anywhere. In almost all instances, the petitioner is the plaintiff in this case, which means the gun law has previously been upheld, and a Supreme Court accepting that would give them an opportunity to reverse a lower court's decisions. Okay, listen, I would link up all of these cases down below, but candidly, that's going to be way too many links. But what we are going to do is we're going to link up the Duke Center for Firearms Law out of Duke Law School. Why? Because they do a fantastic job of tracking all of this, and we'll put a link for their tracker down below. Okay, now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information down there in the description box. If you got an idea for a video we should be doing around here, cool. You click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the information on how to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.
Therein lies why we say in the legal defense sector that we are the most value-centered, cost-effective legal defense in the space, and we are. There's no question. Now, again, I've said before, we've got great competitors out there. They have outstanding products. We admire them. They pave the way for us. You know, we analyze the folks out there that are doing the same thing we're doing, and we took some great ideas from them, and we went down a path of believing that we were going to do it with a service aspect, a servant's heart, and we have again. Our number one goal has been to serve others first in a way that the industry hasn't seen.
Right to bear, that's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.